you. Thank you. All right, Molly Huber. She is the outreach coordinator with the Minnesota Digital Library. She joined the Minnesota Digital Library in 2014, having previously worked at the Minnesota Historical Society and the Minneapolis Institute of Art. As MDL's outreach coordinator, she develops and manages digital projects and leads the standardized rights statement implementation team. So, Molly, if you're there,
I am.
it's all you.
Sure. All right. Thank you, Kristen.
Yep.
And hello, everyone. And thank you for coming. And from Kristen's intro, it sounds like you may already have some questions saved up for me. Feel free to ask them during the presentation or we will have time after. So next slide, please. As Kristen said, I'm Molly Huber. I'm the outreach coordinator for the Minnesota Digital Library. The Minnesota Digital Library aggregates digitized archival materials from museums, libraries, historical societies, and museums from all over Minnesota. We have almost 200 individual contributors and over 55,000 records, encompassing well over 200,000 digitized items. So please visit us at mndigital.org and check it all out if you have not before. Next slide, please. So why should we have standardized rights statements? Next slide. So standardized rights statements are super helpful because when you're a big aggregator as we are, you get these crazy rights statements that are often not really helpful. These are actual examples of rights statements formerly appearing in the Minnesota Digital Library with identifying information removed to protect the innocent or the guilty. But they are, as you can see, they're really not very clear. It's a lot of gatekeeping. It's a lot of not very useful information. Contact us for this. It may be copyright, but it's all on you to look it up. I mean, there's all these things that, what's the point of having those? Next statement, please. Next statement. Next slide. There we go. Okay. And also, when we thought about rights in the past, we were much more self-focused, as organizations, and those previous statements kind of reflect that. It's like it was more about protecting ourselves or thinking about, ourselves as the holders of these items or not wanting to get in copyright trouble. We only primarily thought about putting things online only when we're thinking about if we could use it. If we could use it, limiting our risk, controlling the access to the information, where we stood with that information. But that's not very helpful to our users, and it does not encourage use by, like, say, History Day students, as Liz was just talking about, and teachers. We want people to use our stuff, and in putting it out there, we're trying to make it accessible and more useful. So these old rights statements were not very helpful. Next slide, please. We also had some kind of different understandings about copyright ourselves. There was long and over focus on the magic year of 1923, and that was really just a quirk of United States copyright law. For reasons known best to Congress, they stopped copyright for about 20 years at anything published. That's very key. Published before 1923 had no copyright in the United States, and everything after that did not, for like 20 years. So we focused on that a lot, but it only ever applied to published works. So there's this whole realm of unpublished works, which
Yes.
makes
I can't believe this. I'm telling you.
Oh my God.
So there were many people who focused on it, but many of our collections have a lot of unpublished items, especially like archives and historical societies. We have a lot of family photographs, letters, things like that. Also, then eventually that law changed, and now for a couple, 4 years, because I know we're up to 1926. The law unfroze and things started moving forward again. So now things that are published before 1926 are no copyright in the United States. Next year it'll be as of January 1st, 2022, it'll be 1927. So that's something to keep in mind. And again, and some of the years for unpublished works are changing too, which I'll get into that a little farther along. Another common mistake that was made by all of us is that sometimes thinking that if we physically own something, that we hold the copyright as well. And usually that's not the case, honestly. Unless copyright was specifically addressed in the deed of gift when the item was given to you or when it was collected, the copyright rests with the copyright, the creator and their heirs. So that's another funny thing to think about, that physically owning something. I mean, think about it more like a library. Just because a library has a copy of Tom Clancy's latest novel or whoever's a popular author right now. That doesn't mean they have the copyright to that novel. They just have possession of it. Someone else holds the copyright. So it's very similar there. And then a final point that just as we get more into what standardized rights statements are is they're not licenses. So sometimes people try and say, oh, well, you know, I own this item and I want to share it, so I'm going to apply a Creative Commons license to that. But you can't do that unless you are actually the rights holder. So there's some confusion. We can get into that a little more later too if people have questions. But just in general, you can't withhold or grant copyright permissions or apply a license for a copyright to something that you don't actually have the copyright to. So next slide, please. So we're trying to move to a more external focus on rights, thinking about the user and making it easier for them, assessing whether anyone has rights in the object, and yes, as I said, really thinking about that public usability factor. So this is an example from something in the University of Minnesota's collection that has no copyright symbol for it, but we'll keep moving on to the rights statements and do more examples in a minute. So next slide, please. So what are these standardized rights statements that I keep talking about? So some years ago, a group of people actually from the Digital Public Library of America and Europeana, which is kind of the equivalent in Europe, got together a committee and designed these 12 standardized rights statements, which are available at rightstatements.org. Next slide, please. These statements were meant to be high-level summaries of the underlying rights statuses of the digital objects they apply to. They're meant to be descriptive labels. They can be used by cultural heritage organizations broadly, or anyone really, to indicate the rights status of digital objects made available online. And they're designed both to be human readable, so they've got a descriptive component, and then also with machine readable with a stable URI, so that linked data, they're linked data ready and friendly. Next slide, please. All right, so there are 3 categories of these rights statements. There is in copyright, the statements for works that are in copyright. There's no copyright for works that are not in copyright, and other for works where the copyright status is unclear for some reason. Next slide, please. These 3 categories break down into 12 rights statements. There are 5 under in copyright, 4 under no copyright, and 3 in other. We found for the Minnesota Digital Library, and you might find for many of your collections as well, that we really only use 6, the ones that are highlighted in green there. So in copyright is pretty straightforward. It means in copyright. And I should say before I get farther, these rights statements primarily apply to US laws. And as we apply them for the Minnesota Digital Library, and it applies to US laws primarily. We are not trying to ascertain international copyright. You do see that one EU orphan work. That is one we clearly wouldn't use because that only applies to the European Union, and there's no law around orphan works in the US, which again is more in the weeds that I'm happy to answer questions about later if people wish. In copyright, educational use permitted and non-commercial use permitted are in copyright, but with that means if something came in and the copyright owner granted you permission to use it, but they said, well, but you can only use it, you can't make money off of this. You can only use it for educational. No, you only use it for non-commercial. Nothing in the Minnesota Digital Library falls under that kind of contractual restrictions. So we just don't even use those. We do sometimes use the rights holder unlocatable and unidentifiable, which is really just in copyright with some additional information. You're saying, we know it's in copyright, but we're not sure who holds the rights. For the use cases, that doesn't really, funnily enough, doesn't always matter who holds the rights, but just that you know that someone does. And that's often that particular statement is often a sign, well, let's do a little more research if we want to and do some digging and find out who owns it. In the no copyrights section, no copyright United States, which is basically what you would probably have called it public domain in the past, but I will get into this in another slide, but I'll say it again here because it's worth repeating. Public domain as a legal term actually means no copyright laws anywhere in the whole world. And as I said, in these laws, we're really focused on US laws, which is why we use that NCUS or no copyright United States in preference to public domain per se, because we're not really focused on finding out if something is in the public domain in both the US and Canada, for example. I mean, Canadian copyright laws are quite different than ours, even though they're our near neighbor. So things that are out of copyright in the US are in copyright in Canada and vice versa. So there's different rules there. So we just stuck with that no copyright United States. Those other 3 under that are kind of the reverse of what I said in copyright, educational use permitted and non-commercial use permitted. These are sort of like, there's no copyright, but there's some sort of contractual restrictions or legal restrictions. That often comes up, say, with like HathiTrust items that somehow, even though there's no copyright, there's some sort of restriction on use. Again, that's not something we ever encounter in MDL, and you might not in your work either. So we just set those to the side. The three other statements, though, are very useful. So one I would use with caution, two are super useful. So I'll say it that way. Sorry, I overspoke a little. The one I would use with caution is copyright not evaluated. And that one is meant to imply that, or actually it even explicitly says in the language associated with it, that we've done some preliminary copyright research, but we haven't had a chance to really dig into it. So it's not that it's not evaluated at all. We've evaluated it enough to know that feel pretty confident sharing it, but we want to do more. But it can read as copyright not evaluated. We didn't, you know, I mean, so it could potentially open you up to some risk or some challenges. And it looks like maybe you didn't do your work. So we allow that statement to be used in MDL for our contributors, but we really discourage it. But no known copyright and copyright undetermined are super useful, because no known copyright is like when you're pretty sure there's no copyright in the United States, but you're missing some key pieces of information to actually be able to definitively say that. And then copyright undetermined is when you're really just missing a lot of information. You know, you have this thing, you have some information about it, but you just don't have enough to know if you really can say if it's in copyright or no copyright or no known copyright with confidence. And it is funny because you'll find a lot of this too, if you engage in rights work, a lot of it has to do with your time, but really your tolerance for risk too, and what you feel comfortable saying, you know, about the items in your collection and the level of knowledge you have. So next slide, please. So before we get too much farther, I'm going to dig into some resources for you. I just wanted to give you a quick view of how rights statements, standardized rights statements actually look implemented in the Minnesota Digital Library. So this is an example of an actual item. The web link is there. It's aerial view of the west side of Northfield, and it has this nice, each of these statements have a nice standardized symbol. It appears right under the image itself. So you can quickly, as soon as you get in the record, you can see right there what its copyright status is. And then as you scroll down through the metadata, farther down, we have a separate field that says rights, and it provides the words, you know, the descriptive words and the link to the stable URI, which also takes you to the website and tells you what the statement is. So we've got the copyright information both at the top and then further on down, so you can read more in more detail what that really means. And again, I want to emphasize, if I haven't done this before or enough, that these are not legally binding. These are really just descriptive pieces of metadata. They're just additional information that you are providing, and in a way that is not, I'm not a lawyer. I don't know if any of you all are lawyers, but I'm not giving legal advice and giving this information. I am just saying, to the best of my knowledge, this is the most accurate status of what I think this item is. And if you get more information over time, as you might find, you might have time to do research, you can change that. You can say, you know, I thought it was in copyright, or actually, even as the years change, say something that was made in 1926, right now, it's still in copyright, a published item. Next year, in 1927, it'll be in no copyright US. So you might want to go back and change that label and reflect the more accurate status of that item. So next slide, please. So we at MDL have put together a number of resources that are available on this page on our website. There's information about our rights project, about rightsstatements.org again. We have some videos that we share with our contributors about how to apply rights statements. And I'll say this now and I'll try and say it again. If you're interested in rights training, we are offering one, rights statements implementation training. We're offering one on Tuesday, August 17th at 10 a.m. for free. And I'll put the link to sign up to that in later if anyone wants to join. You don't have to be an MDL contributor to be there. But more importantly, probably to you all, is we have provided some reference guides. We have a quick guide to the rights statements, the 6 that we think are the most useful, and even more importantly, we have a workflow to help you get to those rights statements assignments. So let's go to the next slide. Here's a view of that quick reference, and this and the workflow are both available for download for free, freely accessible through that website. So this groups them into in copyright, when someone else owns the rights, when no one owns the rights, which is no copyright, and when you're unsure about the rights, which maps to that other category. And then next slide. This document, though, is really the key. This is the one that you can use, doesn't matter. It applies throughout the US. You don't have to be from Minnesota. That other one is just a nice, quick, handy guide. But this one actually walks you through the process of doing the rights implementation. So it asks the three basic questions that you really, when you're thinking about an object in your collection, the three main questions you want to start with is it a published document? Is it an unpublished document? Or is it a government document? And when I say government document, I mean federal government document, because the states have their own laws related to whether a document is no copyright or not. Everything according to US law, everything created by the federal government is considered not to have a copyright because it's publicly funded, and US law has set it up that those things, everything created by the federal government has no copyright and can be freely used by United States citizens. However, state governments have different rules. And for example, for Minnesota, Minnesota state government documents are treated as a published document. So they follow that workflow instead of the government document workflow. I have to admit, I'm not sure what the law is for Wisconsin. So that's something that you might want to look into. But this document breaks down the basic questions that will almost always and fairly quickly get you to a standardized rights statement for the items in your collection. And we update it every year and make it available through our website. So this is the version for 2021, because as I mentioned, if you can see, I know it's too small. Well, it's good to know, Emily. It's super small, but you can look at it yourself online. The yellow dates are the ones that move according to US law. So every year we update those yellow dates. So like I said, the published document right now, published prior to 1926, very soon that year will be 1927. So we update those every year for everyone. So next slide, please. And for a much broader array of resources, we have the ones that we have created, but I used to be I was co-chair of the working group, Rights Statements Working Group for the Digital Public Library of America. And we put together a website called the Rights Portal, which aggregated, when I rolled off the committee about a year ago, well over 60 rights implementation resources from all over the country for everything we could find. And we put it together and made it available for access or download via this site. So there's a browsable, searchable. You can go in there and search for what you like, what type of tool you need, and there's many tools and a very broad range of information collected there. So I highly recommend checking it out. Again, it's free and available, and it's establishing a community. They're also establishing a community of practice there so that you can connect with others who are engaged in the same type of work. All right, so I've already talked for about 20 minutes. I do it, so we'll just quickly go through a couple examples just to show you. Next slide, please. Things from MDL that show you an example of each statement. All right, so this is an example of something that's in copyright. And why is it in copyright? If you follow through the workflow, it is an unpublished item, and it was made in 1953. So unpublished items made after 1951 are still in copyright. So it's as simple as that. You just doop, doop, doop. And there you are. Eventually that's going to turn over in about 2 years because it'll been created before the rolling date. So, but right now it's still in copyright. So you can actually determine something with having kind of comparatively little information. Next slide, please. This one is one, so we know who created it and approximately when. She died. So this is another unpublished item. It's a Christmas card that she used to send to about 200 people, but it's still considered, it's unpublished. It wasn't widely available, as personal. And Hilma died in 1972. So US copyright is that the creator of an item holds the copyright until 70 years after their death. So clearly, we are not 70 years past 1972. So, but what makes this interesting, so you could say in copyright and leave it there. However, if you want to use this label or dig a little farther, Hilma never married, didn't have any children, so does not have clear heirs. So upon her death, her rights in this item descended to whoever her heirs would be, but she didn't have children. If it was children, then it would have descended to her children. She probably had nieces and nephews. And you could look into that if you wanted to and try and get their permission, maybe to put this in a calendar or use it in some other way. You don't have to do that, but it is something if you want to, you can try and trace down who that rights holder might be. Or you can just say in copyright and leave it at that, because according to the laws, that is where it is at. Next slide, please. This one is a very clear-cut, no copyright United States. And why? It's because it's a published item That was, you can see it, you've got the creator, the publisher, everything right there, and it was published before 1926. So there it is. No copyright in the United States. Is it published? Yes. When was it published? Before 1926. Woo! You got it. Next one. All right, so this is a fun one. This is, sorry, I find this fun. Copyright undetermined, and why? Okay, so we've got this picture of the Bell Lumber and Pole Yards in New Brighton, Minnesota. And we know who did it, Hobart Beisel, and we did it, and took that picture in 1923. 1923, sorry, 1930, I was reading it right there. So going through the workflow, we're not sure if it's a published item. Could have been published, could have been an advertisement piece. It's for a company that's still in business. Sometimes you have to do a little digging around. Bell Lumber and Pole Yards still exists. So if it was made for them as a commercial item, if it was a work for hire for them, they would still hold the copyright. However, if Hobart Beisel was just a lumberyard hobbyist, I mean, there are plenty of people that are into interesting things. He might have taken this picture for himself. And in which case, we don't have a death date for him. And the published date, you know, we don't know if it was someone who liked lumber yards, you know, we just don't have enough information, as I said. So this is one where it's pretty clear that you would say copyright undetermined, because we're missing some really key pieces that we might be able to find if we did more research, if it was important to us. We could contact the lumber company and see, hey, do you have any records of hiring a Hobart Beisel to take pictures of your lumber yard in the 1930s? Or we could research him as an independent photographer and see, gosh, was he a hobbyist that did thing, you know, I mean, there's different realms you could go, but as you'll find, if you have a lot of items, sometimes you don't have the time to research every single one. If you have a lot of things from Hobart Beisel, then maybe it's worth figuring him out and figuring out what his death dates are, what he did. But if you only have one thing and it's not an important part of your collection, sometimes then you just say, well, I don't have the time for that right now. So I'll come back to it another time, or leave it with copyright undetermined for now. Try and get through these and leave a little time. So next one, please. I'll just do two more examples. No known copyright. So this is a fun one. This is actually a map of Minneapolis Guide to Dining, Entertainment, and the Arts. And it was published in 1966, which is, you know, you'd think would be copyright. However, if we can go to the next slide, if you look on the workflow, during this midpoint of the 1900s, 20th century, there were certain laws about copyright and what the notice had to say and where it had to appear. So the notice had to include the words in copyright. It had to have the little copyright symbol. It had to have certain language. All rights reserved doesn't really cover the language that's required. Also, that information did have to be near the publication information. And this is kind of near, but kind of not. I mean, if you had a chance to look at that map bigger, the publication information is sort of far away. So, and also, even if you did have copyright on a number of items from this time period, if you didn't renew the copyright, it expired after a certain period of time. And many organizations did not bother to renew the copyright in their items. These were the days before easy reproduction of things was possible, and it wasn't as much of a priority for them. So a lot of times they just let those copyrights expire. So for this, it's probably not in copyright for those many reasons, but we're not entirely sure. So this is a good example where you could use no known copyright. So, and I see I have just about a couple minutes left. So next slide, please. Again, just copyright not evaluated, public domain. Mark, as I said earlier, probably want to use those cautiously if you're gonna, because it might not apply to what you want to look like you're doing the work, and then also the public domain might not apply to your items. So I did include some other examples in case we had more time, but I'm not sure we do. So let's go to the second to last slide, Kristen, where I have questions. And if anyone wants to follow up with me about any other examples, we can, but now's a good time for questions.
I'm not sure you breathed for 25 minutes.
I'm sorry if I talk too fast. I'm
No.
a fast talker, everyone, so I apologize if I went too speedy.
You didn't. You were trying to get all the information in. And I think I said this in the chat, but we'll make sure to share all of this information after the fair also. So if you didn't catch it, no problem. We'll share it with you.
So Molly, we had a question that came in chat, and just to be a little more general about it too, because this comes up a lot. So some of the examples you showed from the Minnesota Digital Library are things that are in copyright, but you're still, the institution has decided to put them online. So can you talk more about that? Are they getting permission, or how are they making those decisions?
That is often because many things that are shared in this way, particularly like through MDL or other educational means, as long as they're not like heavily commercial, like I said, I used Tom Clancy novels as an example, you wouldn't share that. But these are things that we think would be covered under the United States Fair Use Law, so that they're being shared for an educational nonprofit purpose. And so that even though they're in copyright, they can still be used and shared in this way. If you were starting to try and use them commercially, then that would be, start putting them on t-shirts or mugs and selling them for your organization, then that would be a different case. But this is just sort of a general educational sharing. And it's so we consider that it's covered under fair use. Again, me not being a lawyer, but that is where it would be.
And there's some specific protections for libraries and archives, and
yes, there are.
Yep.
That they're allowed to share. There's different laws that give much broader rights.
The scale of risk is low. Yes.
Yep.
So then I think
and I will say most times, again, because I mean, people aren't upset you're sharing their stuff. I mean, even if they are the copyright holder and they find you, like I even just got another article email the other day of someone saying, "Oh, I'm so glad you're sharing that picture of my grandpa." They're always excited. Even if the man who contacted me, that he might actually technically be the rights holder of that photo. I don't know, but he was just like, "Oh, wow, it was such a great thing to be browsing through and seeing my grandpa there." So again, it's sort of the good intent. You're not trying to, and you can take stuff down too. I mean, that's the beauty of digital. If someone does contact you and they're upset, well, you take it right back down. So, but we've never once, knocking on wood here, been asked to do that for those reasons in 15 some years of having the Minnesota Digital.
So Russ had a follow-up question in chat, kind of about educational use and fair use, and would that include social media, like a historical society sharing something on their social media account?
Yes. Again, there's not really any established law that way, and it's fairly well established practice that organizations do share this stuff via their social media all the time, so that there's a good community of practice out there that would probably protect from legal exposure. Again, I'm not a lawyer, not speaking with legal advice, but we share stuff on our social media all the time, for example.
I think we're going to call it there, if that's okay.
Of
but
course.
I know that this next slide has your contact information.
It does. And if it's okay, I'm going to throw the link to my training thing in the chat too, in case anyone wants to join us in 2 weeks. 2 weeks from today. I'll just do that quick.
No problem.
And if you have any questions or want to follow up with me, you're welcome to contact me. I don't have to be from Minnesota. Rights training too. Feel free to attend. It's going to be a lot of the same information, but we condense the rights statements part and we do a lot more working through examples. And I'm thinking we'd probably have a lot of overlap between our materials, so you could learn from just working through the workflow and having a chance to think about different types of items.
Wonderful. Thank you so much, Molly. This was wonderful. And I hope it answered a lot of folks' questions. And you may be getting lots of questions from our participants as well.
Wonderful.